Hello everyone, welcome to Indian Judicial Service. Today we are discussing here the Indian Contract Act 1872. This video is the 13th part of top 300 MCQ of Indian Contract Act video series. And if you have not watched the previous video, all the link of previous videos are available in our description box. And those who want the PDF file of this video series, the PDF file will be available in our Telegram group. And the link of Telegram group is also available in the description box. This video is very important because today we are discuss here the basic difference between the contract of indemnity and contract of guarantee, means section 124 and 126. And so this question is many times asked in various previous and pre and mains exams, so that's why we focus it here. And now we covered only 10 questions because if we cover 15 questions the video will lengthier. That's why we take only 10 questions. Before starting this video, I request you please like and share our videos. Now come to the point here. Question number 181. The creditor is a person. So before solving this question, first of all we discuss who is creditor, who is principal debtors, and who is sureties. And we also discuss here the contract of difference between the contract of indemnity and contract of guarantee. So let's come to the points of these topics. So first topic is here surety. So who is surety? So surety, a person who gives. So this is very important. A person who gives the guarantee is called surety. So who is surety? A surety is a person who gives guarantee. Now second person here. So in contract of guarantee there are the three persons. So first person is surety, second person is principal debtor. So who is principal debtor? Principal debtor is the person in respect of whose default the guarantee is given. So such person is called principal debtor. Now who is creditor? So creditor, a person to whom, this is very important, a person to whom the guarantee is given. So guarantee is given is called creditor. So these are the three parties in contract of guarantee. Let's discuss here the difference between the indemnity and guarantee. So in first point, the indemnity, there are two parties, but in which parties here? Name of the parties. So indemnifier and indemnity holder. In the case of guarantee, there are three parties. So these are the very important keywords. In indemnity there are two parties, and in guarantee there are three parties. First here creditor, principal debtors, and surety. So second important point here, there is only one contract between indemnifier and indemnity holder in the case of indemnity, but in case of guarantee there are three contract, and one between the principal debtors and creditor. So there are the three contract in guarantee. So first contract between the principal debtors and creditor, and second contract is there between creditor and surety, and third contract between surety and principal debtor. So this is the second difference between indemnity and guarantee. Now come to the third one. The liability of indemnifier is a primary liability. So in contract of indemnity, the liability of indemnifier is a primary liability, but in the case of guarantee, so the liability of surety is secondary and arises only if the principal debtor fail to perform his obligation. So this point is most important point here. Now come to the another point. The liability of indemnifier arises only on the happening of contingency, but in the case of guarantee there are existing a legal debt, the performance of which is guaranteed by surety. Now fifth point here, the indemnifier act independently without any request of the debtor or third party, but in case of guarantee, under guarantee it is necessary that the surety should give guarantee at the request of debtor. So this is very important point. In guarantee the surety act according to the request of debtor, but in indemnity there is no need to request. Without any request it act upon their work, so upon their indemnity. So now next point, indemnifier can sue, indemnifier cannot sue the third party for loss in his own name, but in case of guarantee the surety after discharging the debt can sue the principal debtor. So now last point here, indemnity is for reimbursement of loss, but in case of guarantee, the contract of guarantee is for surety, so surety of debit. So these are the basic difference between the contract of indemnity and the contract of guarantee. So definition of the contract of indemnity is provided in section 124, but the definition of guarantee is provided in section 126, and we are not discussing here because these definitions we discussed in previous video, and if you are not watched previous video, please watch previous video before watching this video. Now come to our question here. So question is here, the creditor is a person, so it is very clear here, a person whom guarantee is given. So answer is here option A. Now question number 182, the guarantee has to be in writing. Option B, can be oral. Option C, can be oral or in writing. Option D, neither A nor B. So answer is here option C, the guarantee can be oral or in writing. Question number 183, the liability of surety is option A, conditional on default. Option B, independent of default. Option C, can be conditional and can be independent. Option D, either A or B. So it is clear here, the liability of surety is conditional. So surety is always liable when the principal debtor in default. So in this case, the liability of surety is conditional on default. So answer is here option A. Now come to next question. Question number 184, a valid guarantee can be given. Option A, only if there is no principal debtor. Option B, only if there is a principal debtor. Option C, irrespective of any debt. And option D, both A and B. So it is clear here, a valid guarantee can be given only if there is principal debt. So answer is here option B. Now question number 185, guarantee can be valid. So here a guarantee can be valid. Option A, can only be of a present debt. So it is here related to the guarantee can be valid in present debts. Yes, it is a correct statement here. Now option B, can be of past debt. Yes, it also created correct here because the guarantee can be given for past debts also if some further debt is incurred after the guarantee. So this statement is also correct here according to the question. Now option C, can, so it is wrong, misspelled here, it is can be of future debt if some debt is incurred after the guarantee. So this statement is also correct here for the valid guarantee. So answer is here option D, all of the above. Now next question here 186, the guarantee obtained by misrepresentation or concealment is. So the guarantee obtained by misrepresentation and concealment is option A, invalid. Option B, valid. Option C, voidable. And option D, illegal. So the guarantee obtained by misrepresentation or concealment is, such guarantee is invalid guarantee. So answer is here option A. Now question number 187, which of the following is a valid guarantee? Option A, the guarantee of a minor debt. So the guarantee of minor debt is a valid guarantee because the minor is not here dealing with the contract of guarantee with the guarantee holder, means the surety and creditor. So because the responsibility of guarantee is there, so such contract is valid contract here. And option B, the guarantee of debt of company acting ultra vire in obtaining the loan. And option C here, both A and B. Option D here, neither A nor B. So in this case option B, the guarantee of debt of a company acting ultra vire. So this company is acting ultra vire in obtaining loan. So this guarantee is not valid here because the act of the company is here ultra vire, and the guarantee of a minor debt is a valid guarantee. So answer is here option A. Now question number 188, the liability of surety is option A is co-extensive with that of principal debtor. Option B, extend to the whole of the amount for which the principal debtor is liable. Option C, both A and B. And option D, neither A nor B. So this question is directly related to section 128. Section 128 dealing with the surety's liability is co-extensive with that principal debtor. So answer is here option A clearly according to section 128. So the liability of surety is coextensive with that of principal debtor. So answer here option A. Now question number 189. Under the contract of guarantee, the liability of surety, so option A here can be limited, option B here cannot be limited and has to extend to the whole of amount due from the principal debtor. Option C can be extended to penalty also, and option D both B and C. So according to the Contract Act, the contract of guarantee, the liability of surety cannot be limited. So it is not limited, it has extended to the whole of amount due and from the principal debtor. So answer here option B. Question number 190. A, a guarantee which extends to a series of transactions under section 129 is called. So section 129 dealing with continuing guarantee. So continuing guarantee means a guarantee which extends to series of transactions is called continuing guarantee. Now option A an absolute guarantee, option B continuing guarantee, option C an invalid guarantee, and option D a conditional guarantee. So section 129 dealing with continuing guarantee. So answer of this question is option B. Now finish this video. If you like this video, please click on like button, and if you are not subscribed our channel, please subscribe it. Thank you for watching Indian Judicial Service.